Hi everyone, it's noon Central Time. I'm David Glaser. I'm here with Jim Platt.
Hello.
And we're here to talk about antitrust and healthcare consolidation. So just the usual minor housekeeping details. So first off, if the internet starts to slow down and our sound gets crummy, it's probably not anything we can really control, but you can always dial in using the number that you see in the bottom right corner of your screen. So use that if you start to have audio issues. That same box is this place where you can type questions to us. Jim and I both like answering questions, so type those in. We may answer some in the middle, but more likely we'll hang on to those for the end. Last administrative thing, our next webinar, which will be April 13th, same time, 1 Eastern. Let's see, that's 5 hours, well, that's 9 a.m. In Alaska. Will be Steve Helland and possibly one other person talking about what you need to know when you enter into computer contracts. Steve has worked with a bunch of clients of mine, and I'm struck by the number of them who have called me afterwards to say how amazing his advice was, and that he thought of things that they had never thought of. I never get phone calls like that about my advice, so I'm envious of Steve, but I think that that'll be a really worthwhile webinar. All right, so let's jump into the substance. I'm going to give a one-slide summary, and then Jim is going to talk about the stuff you're probably most interested in, accountable care organizations and sort of the current buzz in antitrust, and then I will finish off by talking a little bit about mergers and some miscellaneous antitrust material. The antitrust big picture is an interesting one. If you think about the idea behind antitrust, the idea, and it really came out of the early 1900s, is that competition is good. And we want to encourage competition, and that the best form of competition comes through regulation. Oddly enough, this is an area where the original conservatives were big fans of regulation. They thought that if you regulate the market a little bit, it will flow basically more competitively. And so it's the idea of putting in a little bit of regulation to encourage competition. What's happening right now in healthcare, though, is very different. This is, I bet, the only time I'll ever cite the Spice Girls. But right now, in health policy, every time I look at it, I feel like the question is, tell me what you want, what you really, really want. Because the government is sending two totally contradictory messages. They want competition. But really, the big message, as Jim is going to talk about, is they want consolidation. They want integration. We want doctors and hospitals practicing together. We say that out of one side of our mouth. But then we say things, and we say, hey, we don't want an MRI in every corner. You know, we want to have certificate of need so that we have centralized planning. But then we go back to this antitrust thing, which is saying competition is good. And that schizophrenia is a huge problem, and it makes it very difficult to plan or to understand what's happening. And Jim will talk about this a bit more, but the different regulatory agencies don't necessarily agree. And so you might have the Department of Justice feeling that a particular arrangement is acceptable, and the Federal Trade Commission disagreeing. Or CMS thinking we want integration, and the FTC saying this is no good. And that's going to make life really difficult. Now, this is an area where policy is as important as the law, but there is both policy and law, and they overlap. But it is always helpful to think of a core principle, which is antitrust law is designed to protect buyers. And ultimately, that means consumers, not necessarily insurance companies, but for those of you who get frustrated on the unfairness between insurance companies and medical providers, if you're a medical provider, you have to understand that the insurance company is viewed as a buyer, and the law works hard to protect them. So, and finally, antitrust covers a whole bunch of different terms, or a whole bunch of different ideas, and we'll be talking about those ideas more as we go on. So I'm going to turn this over to Jim, who's going to walk you through the important stuff.
So what David and I are going to talk about today, I'm going to talk a bit about what's causing consolidation, how antitrust law impacts certain types of consolidations. In particular, I'm going to be talking about networks and ACOs and the new next generation of IPA-type models. And then thirdly, I'll talk about recent antitrust enforcement activity. David will then follow me with a discussion of mergers and other miscellaneous antitrust issues. This is a particularly relevant topic. As David mentioned, the new Healthcare Affordable Care Act encourages consolidation in the form of accountable care organizations. And the theme of that law wants providers to collaborate and to join together and to form organizations that and relationships that hopefully will bend the trend in terms of the increase of healthcare spending. At the same time, though, the government is concerned about competition and the impact on competition. This is also a particularly timely topic because the regulations dealing with accountable care organizations are to be issued nearly any day now, and those regulations will hopefully give us more guidance in terms of how antitrust law will apply to these new ACO-type entities. It's also likely that as these organizations unfold and as consolidation works through the healthcare system, that there'll be future developments. Not all ACOs will succeed. Not all physician networks are going to be able to do the sort of things that are going to be able to deal with the sorts of things we want to encourage, namely decreasing healthcare costs. But they will have come together to negotiate with third-party payers, private payers as well as public payers, and those organizations will continue, presumably, to exist. So over the course of time, I wouldn't be surprised to see a lot of collaboration between providers and payers, but also in some communities, potentially more confrontational negotiations, as some of these relationships may not necessarily pan out and be good for all parties long term. So future developments are most certainly likely. I want to just talk just briefly about what's causing consolidation among healthcare providers. Certainly this is going to be no surprise to most of you listening in that access to capital, increasing costs of technology, the expense of electronic health records, the ability to borrow in larger systems, the availability of tax-exempt bonds available in nonprofit exempt organizations. That ability to access capital is a key driver because it's becoming increasingly expensive to provide health care services. So the larger organizations with greater capacity and greater access to capital is a major driver. Among the specialty groups, what's driving consolidation is that as specialty groups become more subspecialized, as we develop specialists within specialist groups, they're seeking a larger group of specialists within which they can practice. Healthcare reform, as I mentioned, the Accountable Care Act is certainly driving a great deal of consolidation. Market reforms in terms of what's going on in the private insurance industry also encouraging consolidation. Overhead pressures, certainly in the smaller medical groups and smaller rural hospitals with declining reimbursement from government payers, a major driver of consolidation, particularly and increasingly so in the rural hospital market. Greater sense of security for physicians. Physicians see that the opportunities to consolidate with larger healthcare systems will give them financial security, economic security. The desire on some part of physicians to just practice medicine, that they really don't want to be involved in the administrative aspects of the practice. These two bullet points to me are concerning because if the next generation of physicians coming out of residency programs really just want to practice medicine and don't want to be involved in the administration and the sorts of things that go with the practice of medicine, then who will be the next generation of leaders that will indeed help us to better understand the most effective ways to deliver medicine? So it'll be interesting to see how that plays out over time. Better contracts with third-party payers. Larger healthcare organizations tend to have better contracts with payers as opposed to the smaller groups, and so the smaller groups seek refuge by consolidating with the larger groups to take advantage of those contracts. Generational aspects among particularly primary care doctors, that doctors coming out of residency programs in primary care don't want to have to buy in and don't want to have to reduce their compensation in order to purchase the next new piece of technology. So these drivers of consolidation have caused a lot of mergers among physician groups. They are causing mergers between health systems and hospitals. They have certainly over the years created lots of sales of primary care groups to hospitals and some specialty groups to hospitals. But the first bullet point, that now that we have the new healthcare law and encouragement around accountable care organizations, this has really created a wave of accountable care organization formations and discussions between physicians and hospitals about how to come together, short of merger, short of acquiring practice groups, in order to work more effectively and hopefully get our arms around the increasing cost of health care. This is really an opportunity for both hospitals and medical groups to work together in a collaborative fashion. It saves the hospital the money that it otherwise would have had to pay to acquire the physician groups, and it gives the physician groups who still want to stay independent the ability to stay independent. So the creation of these networks and the creation of these ACOs is advantageous for both the hospitals and the physician groups. It also allows them to come together more rapidly to work on these cost of care issues than would be the case if they were to go through the traditional merger and acquisition type way of consolidating. So it certainly is driving a lot of consolidation going on now out in the healthcare provider industry. So this then leads us to the antitrust topics. I'll talk a bit about what exactly are these ACOs, accountable care organizations, and how the antitrust laws are going to apply to these and other contracting networks. David then will talk a bit about how the antitrust law affects mergers and other consolidations, and what other provider activities may run afoul of antitrust laws. So first, a bit about accountable care organizations. Accountable care organizations, or ACOs, is the type of entity that's been accepted under the recent Healthcare Reform Act, accountable care organizations. They involve a formal legal structure that permits the receipt and distribution of payments, so new entities are being created or existing entities are being used as the ACO. They must cover at least 5,000 Medicare beneficiaries, so we need to work out a mechanism to assign Medicare beneficiaries to a particular ACO. Some have commented that that is a large number of Medicare beneficiaries. It may be difficult in rural communities to form their own ACOs if that's the minimum number. So it remains to be seen exactly how that's going to pan out and how Medicare beneficiaries are going to be assigned to particular ACOs. Those will all be dealt with in the regulations. ACOs are to be able to and have the capacity to report to CMS on quality and cost measures. They are certainly intended to and are expected to coordinate care. They are expected to have systems in place that will promote evidence-based medicine, that will be patient-centered, that will supply data to CMS, and that they'll enter into a 3-year agreement with CMS. Note in the description here of accountable care organizations the importance that's focused around coordination of care, patient-centered, evidence-based medicine, and reporting data to CMS. I'm going to come back to the importance of this type of clinical integration in a bit when we talk about the antitrust implications of this. ACOs then, when they contract with CMS, may be paid under a shared savings plan. A shared savings plan would be a plan where CMS will benchmark particular cost of care for this group of Medicare beneficiaries and then measure against that benchmark savings, adjusting for risk and adjusting for other outliers. CMS would then share some of those savings with the ACO. The ACO would then take those savings and distribute those among the provider groups in the ACO. That's basically the notion of an ACO under a shared savings plan. A shared savings plan is going to be a fee-for-service plan, so the providers are receiving compensation from CMS on a fee-for-service basis, but there's going to be an incentive or a shared savings aspect to that, where there's an opportunity to have an upside, an additional point of reimbursement if shared savings are realized. The healthcare law also contemplates that there may be other payment models in the future, some types of capitation, and potentially other payment models that CMS determines improves quality and efficiency. CMS may waive certain federal laws that might otherwise apply to ACOs, namely the anti-kickback and the civil monetary penalties law, not the antitrust law. CMS may also do other demonstration and has been and is doing other demonstration and pilot programs. But the market is not waiting for CMS to come out with its ACO regulations. And even if federal health care law gets sidetracked or gets put down another chute because of the politics, that's not going to change what's occurring in the market, because the market is moving very quickly. Health industry players, third-party payers, large self-insured employers, they're very interested in trying to get arms around increasing cost of health care and attempts to try to bend the trend in those future increases. So they're not waiting. So healthcare industry players are considering already shared savings programs or ways to make bundled payments to healthcare providers for a particular episode of care or a particular, a hip surgery from the time of admission to discharge and all the rehabilitation, to make a bundled payment for that. Global payments and partial capitation contracts already being discussed and being considered out in the healthcare provider payer communities. So ACOs, as they stand today, are being formed with the intention of seeking the contracts with CMS, but they are already looking forward to and contemplating contracting with health plans and employers in new ways. So as you think about ACOs, realize that ACOs will not be limited to just CMS, but will also more than likely contract with private health plans and self-insured employers. So this then raises the host of antitrust issues, and there's many unanswered questions with ACOs in terms of how this is going to play out. For example, are providers that contract with ACOs, are they going to be required to be exclusive? Can they participate with other ACOs? Or will all of their contracting for their services be done through the ACO? Will their ACO contract with all of the third-party payers or just one payer? How will the ACO go about setting the bundled rates? What kind of fee information and information that otherwise raises antitrust concerns when it's shared among competitors? How's that going to be reviewed, distributed, and determined? How about credentialing participants in the ACO? We have a long history of antitrust law in terms of physicians being excluded from medical staffs and exclusivity contracts with medical staffs. How will all of that filter through the courts in terms of physicians who are not allowed to participate or who are excluded from participating in an ACO? And most significantly, how much clinical integration does an ACO need to have to pass antitrust muster? ACOs require a lot of capital. They're important because they're going to need to be able to show CMS that they're delivering on the things that ACOs are required to do under the statute, and that's going to require capital. That's going to require computer linkages and infrastructure. And so that kind of clinical integration is important to ACOs, but how much is going to be necessary is a bit uncertain in terms of how the antitrust laws are going to apply. So here's some interesting statements from the head of the Federal Trade Commission, John Leibowitz, who said last June, if you fix prices, that is, if independent doctors jointly negotiate the fees they charge, we will make you stop. But if you join together to improve patient care and lower costs, not only will we leave you alone, we'll applaud you. And what strikes me about this quote is that it paints the world of physician networks or provider networks as black and white, that there are either those out there that are trying to jointly negotiate the fees, and I'll give you some recent cases on those as at one end of the spectrum, and then ACOs joining together to improve patient care that are going to be fine and that they're at the other end of the spectrum. But I don't think it's going to be so black and white. I think a lot of the ACOs and a lot of the networks that will come together will be a mishmash. They're certainly going to come together to seek contracts with third-party payers that are going to have a shared savings element to them, and they're certainly going to work together on clinical care opportunities. But they're also going to still negotiate a fee-for-service element to those ACO provider agreements. So they're still going to do a lot of the traditional things that the FTC has been concerned about, while at the same time they're doing the same sorts of things that they're promoting under the ACO model. Other recent antitrust developments: last October, there was a workshop involving the Department of Justice, FTC, CMS, and other anti-kickback folks trying to sort out, as these ACOs get developed, how all these things are going to happen, and hopefully when the regulations come out, we'll get some guidance on that. In January of just this year, Christine Varney, one of the leaders in the U.S. Department of Justice Antitrust Enforcement Division, commented that competition in healthcare is still something they're very concerned about, that they're watching over this, that they don't intend to stand by the sidelines. Her comments were interesting in that regard, that they're not going away, that the competition is still a major concern. And as I mentioned, we're expecting these ACO regulations and what they'll have to say about antitrust just any day now. What most people are expecting is that when those regulations come out, that there may be some sort of a safe haven for certain ACOs, that perhaps if CMS agrees to contract with the ACO, one idea is that that ACO would then be given a safe haven under the antitrust law. Whether that would mean that it could then negotiate with private payers under that safe haven as well remains to be seen. But there's been some discussion about some sort of a deeming process where the ACO that contracts with CMS may be deemed to fall within a safe haven. And maybe some sort of expedited review for other ACOs that might go above the thresholds that the FTC has indicated in earlier rulings in terms of the percentage of the percentage of the payers in the market. You know, maybe there'll be some sort of expedited review for them. So the antitrust issues in terms of these ACOs and physician networks basically boil down to this, that Section 1 of the Sherman Act prohibits healthcare providers from engaging in price fixing and group boycotts. And in order to get past those per se, otherwise known as sort of automatic violations of price fixing and group boycotts, you need to be able to show as a network that there's some financial or clinical integration of the parties, or both. You need financial or economic integration or clinical integration or both. Otherwise, you're going to be engaged in price fixing or group boycotts. Those are per se illegal, and you won't be able to proceed. So you need to have something economically integrated or clinically integrated. The FTC has brought over 20 cases against providers that have engaged in rate fixing and group boycotts over the last 10 years. And I know of maybe 3 or 4 or 5 of them just in the last year or two. And certainly major third-party payers can enforce this as well, as can state attorney generals. Now, under the existing law, it is also the case, and we do receive these questions a lot, about, well, why is it that a group of independent practices can't somehow collectively negotiate, but a giant health system can negotiate? We ought to just all go join the big health system, and that way it can negotiate. And that's been perhaps one of the consolidation drivers. Where that's coming from is that under the antitrust law, if you are a single legal entity, that single legal entity isn't conspiring with another organization to engage in price fixing or a group boycott. It is itself a single entity. And this notion that a single entity can't conspire with itself was recently confirmed by the U.S. Supreme Court in a case involving the National Football League and its pricing and contracting for sports gear. But that single entity can still run afoul of the antitrust laws if it engaged in illegal conduct in becoming a single entity, if it acquired that market power through consolidations. If those consolidations were illegal under the antitrust law, then its exercise of that market power as a single entity would be illegal under the antitrust law. So it's not necessarily the case that a single entity gets a complete pass on antitrust law. It really depends on how it became large in the first place. If it became large through mergers and acquisitions, that could raise antitrust issues. If there's not a single entity, then we need, as I said, the financial or clinical integration or both to avoid those issues. So in talking about financial integration, what do we mean? How much financial integration does a network or does an ACO, if it's going to go down that path, need to have? How much is enough? Well, certainly capitation would be sufficient. A predetermined percentage of revenues coming from the payer, some sort of a modified capitation plan like that would be fine. But in a lot of markets, we went through capitation a number of decades ago, and I know that a lot of healthcare providers are still concerned about capitation, about whether or not that's going to be the correct model for the future. So people are excited about the notion of a fee-for-service with shared savings opportunities, less so with capitation. So if you end up with a network or an ACO that's really just looking at fee-for-service with shared savings, is the shared savings going to be enough of a financial integration piece to pass antitrust muster? Well, when you look at some of the antitrust guidelines on these physician networks out there, they're quite critical of networks that came together. You know, maybe the network contracted with 8 payers. Of the 8 payers, it did 7 of them on a fee-for-service basis, and the 8th payer, it had a 15% withhold, but no real way to monitor quality of care, no real way to incent providers to achieve the kind of clinical integration things that they should be looking at doing. And the FTC has said, you know, that's not nearly enough financial integration. You can't take a 15% or a 10% withhold and call yourself financially integrated. You need to do much more than that. I'm going to pass over this and because I want to really get to the clinical integration. So that leads us to the importance of clinical integration. If the financial integration isn't enough, and if we're doing a shared savings, but it's still primarily fee-for-service, then you really need to have significant clinical integration. And the FTC opinion letters, there's a couple of them out there that have talked about clinical integration programs, really stress the importance of providers working together, being linked, having evidence-based medicine, doing those same sorts of things that you saw in that ACO legislation slide I presented earlier. Because if that kind of clinical integration doesn't exist, or if it exists in word only, but not practically being implemented, then you're not going to have the kind of clinical integration, and you probably don't have enough financial integration to pass antitrust muster. The other thing, too, to bear in mind about these networks is that the FTC and the Department of Justice will also take a hard look at the need for joint contracting to accomplish these claimed efficiencies. So is it really necessary, the government could ask, that all of you came together to form this network? Was that contractually necessary to negotiate this agreement collectively? Could you have accomplished this by maintaining your separateness and without have joining the network in the first place? That's a key question that the government also asks in looking at these networks. Clinical integration, as I talked about and as these slides show, focus on evidence-based protocols, lots of information technology, and showing that these organizations are linked and are interdependent in terms of accomplishing the goals of the network. IT plays a huge role in this, and IT, of course, is expensive. These networks should be required to have significant IT infrastructure in order to monitor the sorts of things that they need to do. And enforceable consequences for non-compliance. The government wants to see evidence that if there are providers in the networks that are not compliant, that are not adhering to the protocols or not achieving the goals on a repeated basis, that there's a consequence to that, that they're not just along for the ride to get the advantage of what I see as the fee-for-service negotiation part of this, never having realized any shared savings, but still getting the benefit of the collective negotiation of that. The government wants to see that there's some enforcement action taken against those who are not improving performance inside these networks. If clinical and financial integration aren't present, then of course networks can use the good old-fashioned messenger model. The good old-fashioned messenger model is where basically a consultant shuttles between the participants in the network and communicates certain things back and forth, being very careful not to run afoul of the antitrust law. The messenger models really don't work, in my experience, very well with physician networks, and we've never been particularly fond of them. But it is a model that some people talk about, but it's really not an adequate substitute to the types of clinical integration that you need to make these networks pass antitrust muster. This was another comment, another quote that I thought was of interest, where again we have an antitrust enforcement chief here saying, where the purported effects to integrate are principally a vehicle for exploiting or maintaining market power, or simply a subterfuge for price fixing, then antitrust is there as it should be. Now, in my last slide before David comes back, I want to just touch on some of the recent antitrust enforcement activity that's going on out there. I'll kind of tick through these quickly for you. The FTC certainly is active and interested, particularly in hospital merger and acquisition activities. There is an FTC complaint that was filed not too long ago about ProMedica's acquisition of a hospital in Ohio because they would end up dominating most of that particular, that's Toledo, Ohio, most of that market's hospital care. There's an FTC consent order that was issued last June involving an IPA-type co-op in southwestern Minnesota. That was interesting because that co-op was formed years ago following Minnesota state law at the time that encouraged healthcare cooperatives to form. That cooperative then used its market power to negotiate with third-party payers, but without much financial risk and with little clinical integration. So the FTC has an order now to disband pieces of that. The next two, Roaring Fork, Boulder Valley, those are two examples of IPAs, sort of the PHO, physician networks, that you regularly see the FTC getting consent orders against, where physicians have basically come together to attempt to collectively negotiate with third-party payers, again, with little or no financial integration and with little or no clinical integration. The Carillon Clinic's divestiture of a couple imaging centers, this is more of a straight-up merger situation where you have a clinic that acquired, or a clinic that was part of a hospital system, basically acquired the only other two independent imaging centers. This is Roanoke, Virginia, if I recall this correctly, leaving only two in town, this one and another one in town. And the FTC required that organization divest them, and interestingly put them back in the same position they would have been in had they continued to be independent entities. So, you know, you have a healthcare organization being forced to financially divest itself and to reestablish those organizations back in the position they would have been absent the acquisition. The Scott and White Healthcare one, interesting case where they acquired a hospital. They used what's called the failing firm defense to acquire the hospital that was going to go out of business if they didn't rescue it and turn it into, I believe, a children's hospital from an acute hospital. That ended up proceeding because they were able to show the FTC that nobody else would have acquired and operated that hospital as an acute care hospital, so they ought to be able to acquire it and then change it. And so that investigation was closed without action being taken against them. Altabeta Group's case, that's another IPA-type model case. Lots of IPAs out there where physicians have gotten together to try to negotiate together and haven't had the clinical or financial integration. Then the Evanston Hospital one has been the one that's been out there for quite some time. That was another hospital merger case in Evanston, Illinois. What was interesting about that case was that when the dust all settled on it, the hospital that was acquired was allowed to be part of the healthcare system, but it must negotiate its third-party payer contracts as if it were a separate entity. So it needs to wall itself off from the rest of the system and pursue its own contracts, and that payers would be able to negotiate with it separately from the other hospitals in its system. So what's interesting to me, and as all of this unfolds, is to ask ourselves this question, or rather frightening question, and that is that if this ACO legislation and if this integration into these networks does not succeed in the eyes of regulators and the eyes of politicians at bending the trend in healthcare costs, if it doesn't solve the problem that is out there, then what? What's going to be the next step? Will we have legislation that will allow payers to negotiate with separate parts of healthcare systems, as in the Evanston Hospital resolution? Are we going to see forced divestitures where healthcare organizations will have to peel out pieces again so that we can then negotiate and have that competition? Again, that's a great unknown out there, and clearly what everyone is hoping for and expecting is that these networks are going to be able to accomplish the goals of controlling healthcare costs. But we'll all have to see if the systems develop that way, and if indeed we have the patience to allow that to happen. So I'll turn this over to David.
Thanks, Jim. So before I move on to my first slide, if you just look at Jim's slide here, you'll notice the letters FTC pop up a lot. Conspicuously absent are DOJ, the Department of Justice. I'm going to talk a little bit about a situation I had where the Department of Justice investigated a merger. And so some of the other, Jim's already kind of covered negotiations with insurers. I'll talk about that just a tad, but mergers, peer review and stuff like that. And each of these topics have some slides, except the last one. You may think that I am dyslexic and I am trying to make some reference to Monday Night Football, but that last point is most favored nations clauses. And this is an area I almost forgot to include in the materials, but that's popped up a little bit recently, which is, in a most favored nations clause is when someone says, you promise not to give someone else better terms on this deal than you've given us. And so maybe an insurer will say, we'll pay you $90 an RVU or $75 an RVU, but you have to promise that you won't give a better rate to any other insurer. And that came up, was challenged right now in Michigan with Blue Cross Blue Shield. Some states, Minnesota actually is somewhat unique. It has a law that prohibits most favored nation clauses in healthcare contracts. Most states don't have a provision like that, but the government is interested in those clauses because it worries that it inflates the price of healthcare. So Jim talked a little bit about per se antitrust violations. And a per se antitrust violation is something that is automatically illegal whether or not you have any market power. Most antitrust violations only come into play if you are big enough to have market power. Jim talked about the two big exceptions, price fixing and boycott. There, you don't need market power to have a violation of the law. For other things like monopoly or other various restraints of trade, you get into trouble only if you have enough market power. And when the government is looking at market power, it breaks into two areas, the product market and the geographic market. So the product market is what good or service you would use instead of the thing you're buying. So to put it in a healthcare context, there often aren't a lot of substitutions. If you're going in for a chest x-ray, can you substitute a CT scan or an MRI? Well, those aren't necessarily easily substitutable, But, for example, internal medicine physicians and cardiology, they overlap some. So that's the product market. That's usually fairly easy to define in the healthcare context. The more difficult one is the geographic market, which is where people reasonably could go for care. And, that's obviously going to vary based on what we're talking about. So the first thing when you're thinking about the geographic market, you're going to look at what is the market? Is the market by dollars spent? Is it by people in there? Kind of what's the market? Often when you're looking at trying to figure things out, the easiest thing to count is physicians or hospitals. Within hospitals, it gets a little easier because there's often patient data and you can look at market share data. There's no one answer to that. You can look at different ones, and frankly, you can kind of choose the one you think might be most useful for you to use. How you get the data can be interesting. I know when we were working on our Department of Justice investigation, it was in a state where license plates include the county of where the car is from. And so one of my harebrained ideas was to go to the large academic medical center parking lot and just look at where all the cars were from to try to demonstrate that the geographic market was basically statewide because people would travel around the state for care. We don't know exactly what arguments carry the day, but I think that was actually one that was semi-effective. So developing the market data can be challenging, particularly in the physician context. Hospitals have a little more data, but what you have to be figuring out is where people could go for care. So frankly, just knowing where they actually go now isn't that meaningful. You have to figure out where they could go. There's a case out of Omaha and Lincoln, Nebraska that involved cardiac surgeons. And in that case, the Court of Appeals decided that for cardiac surgery at least, Lincoln and Omaha, which are 56 or 54 miles apart, about an hour drive, constitute one market. And that makes sense, but you have to keep in mind it's going to vary from service to service. You'll drive longer, most likely, to get a stent implanted than you might for chemotherapy, which you have to do every week. Your primary care doctor, is a 15 or 20-minute drive reasonable, and it's going to take into account geography. 60 miles in the Midwest might be the same as 3 miles in New York City. But it's how far would people reasonably go for care? Now, when you think about what activity is most dangerous for physicians in the antitrust context, I'm not talking about skydiving or other things, but from an antitrust standpoint, the thing that scares me most is golf. And the reason golf scares me so much is you put two physicians on the golf course, and one is going to say to the other, have you seen that new Blue Cross Blue Shield contract? It really sucks. And the other one will say, it sure does. We won't sign it if you won't sign it. Well, that agreement by itself is exactly the sort of per se violation that Jim was talking about. You don't need to show market share. All the market stuff we were just talking about goes out the window, and poof, you've committed a felony because price fixing is a felony. And so the problem is, psst, quit taking insurance, pass it on, sounds really good, but it is the sort of thing that can get you rung up in a hurry. So that's something you really want to avoid. Boycott, very similar. You know, if you just say, hey, we're not going to deal with this insurer, that is, and two competitors make that agreement, it's a per se violation. Monopolization is the one I'm going to spend more time on now because that's what really comes up when we're doing mergers, which is my bread and butter. And that's one party having enough control of the market to fix price. Everyone who's played the board game has some idea of what we're talking about. One other thing that I'll just toss out to keep in mind, there's a concept in antitrust law called tying arrangements. And it's the idea that someone who has market power in one area uses that market power to force someone else to buy a linked product or service. The thing we all learned about in law school was Colgate toothpaste at one point bundled toothpaste and toothbrushes. And so you could only buy one if you had the other. In the healthcare context, one of the famous cases involved anesthesia. And the question was, is anesthesia bundled with the surgery? And in that case, we're now going back a long time in my memory, but if memory serves, the court ultimately decided you can't really separate anesthesia from the surgery. Now, most of the antitrust laws, with the exception of monopolization, require an agreement between competitors. That's the one entity thing Jim was talking about. And because they require an agreement, there are a variety of activities that may seem illegal that are okay. And one of those is, the fancy term for it is conscious parallelism. The thing where you've seen it in action is airline pricing. So Delta drops its price and all the other airlines match. Is that an antitrust violation? It isn't, unless the parties have agreed. Now, that agreement can be implicit. You don't need to have some kind of written agreement or written contract or anything like that. You can get the agreement either through behavior, emails. I remember Jim used the example once in a speech. I loved this one, the pancake breakfast, where he said, everyone will order pancakes if you're signing the contract and waffles if you don't. And I've stolen that example from Jim a number of times because it's a great example of agreement being subtle. But there has to be agreement. So if you are a clinic or a hospital and you're trying to get negotiating clout, what can you do? Can you say no to a contract that's offered? Yes, you can do that. Can you unionize? Well, in the current climate, unionizing isn't really an option. Because the relationship between physicians and payers is not one of employer and employee. So unions aren't really in play until we get to a situation where doctors are employed by systems. Then unionization, I mean, that's obviously happening. Their unionization might be an option, not my area of expertise. Can two groups agree not to sign a contract? No. That's a per se violation. Can you get big? Well, yes, if you don't become too big, and that's what we're going to talk about now. So one of the things I've become a really big fan of lately is the divisional merger. I think it's a mechanism for physicians to get more control over their lives, although actually, interestingly, not as much in a negotiation standpoint. I think of the divisional merger as more beneficial from an ancillary standpoint and through other benefits, but it is a mechanism to get larger, preserve autonomy, and be compliant with the law. So how does a divisional merger work? Well, basically, you become one corporation. You might use, if two groups are getting together, if Jim and I are getting together, we may look at our payer contracts. If Jim's got better contracts, we may use his entity. We might use mine. And this works, by the way, you could be bringing together 3, 4, 5, or you can bring as many organizations as you want. We've worked out on the East Coast with a bunch of solo practitioners and brought them all together into a group but as a bunch of individual divisions. The divisions can be of any size. One doctor, one hospital, 10 doctors, you can have them of varying sizes. The parent board makes, the divisional boards make decisions which are then ratified by a parent board. And you typically have a shareholder control agreement that says the parent board will defer to judgments made by each division unless a supermajority of the parent board objects. And so this is a great way for physicians who are concerned about loss of autonomy to come together in a way that will allow them to offer a broader range of ancillaries, to look at trying to do things like some of the clinical integration Jim talked about. I know one of the mergers we're working on right now, the savings that were realized in things like electronic health record, billing systems, and malpractice insurance were astronomical. It far more than is paying for the cost of the merger. And then basically you have each division within the merger promise to indemnify the others if the other division incurs liability because of a mistake made by the first. So you might get better negotiating clout out of this. Actually, to me, that isn't really the reason to do it. I am much more into this for the economies of scale and the political clout. Political clout is something physicians need right now, and frankly, hospitals could use it too. And so getting bigger is something for folks to think about. All right, I'm going to focus now more on the legal part of this. So monopolization and what does it mean? There are a whole bunch of laws that can come into play. They have fancy names. The one I most often forget about because it doesn't apply as much to clinics as it does to bigger organizations is Hart-Scott-Rodino. If you do a merger that has entities of like with $61 million in assets, there's a federal filing you have to do. There are other folks here who are smarter about that than I. If you're two clinics merging, you probably don't need to worry about this. If you're two hospitals merging, you do. Now, monopolization becomes an issue, or you at least start thinking about it when you hit 40% of the market. If you talk to different experts, they'll toss out a different number. Some people will say 35 is the magic number. But really, even in the 40 to 60% range, things are still pretty mushy. When you get above 60%, that's when you need to worry. Now, generally speaking, if the government thinks that you're too big, the remedy is to bust you up. The good news is that it's almost unheard of for a monopolization to result in any sort of criminal penalty. Now, when I say that the 40 to 60% is mushy, the story that I'm about to describe involved a physician group of 25 physicians merging with a physician group of 5 physicians in a town of 31 of this particular specialty. So we're putting together 30 of the 31 doctors. The Department of Justice wound up looking at it, and it passed muster. Why? Well, it isn't all about the numbers. You look at the numbers, but there's more to it. And so first, what's one of the numbers they look at? You might hear something referred to as the Herfindahl-Hirschman Index, or they'll call it the HHI. And it's basically a chance to throw big words around and complicated ideas, but they take the market share of each player and they square it. And so if you've got maybe Hospital A's got 40% of the market, you square that, that's 1,600. Hospital B has 25% of the market, you square that, 625. You add up all of the squares of the market shares, and that'll give you a number. And this is fairly mechanical, but the government then will take a look, and if you're below 1,500 when you go through this exercise, you're generally considered to be unconcentrated. If you're above 2,500, you're considered concentrated. And what they'll do is they'll then look at that index number both before and after the proposed merger and how much it changed. But that isn't that's not it's not definitive, because the test that the government tends to use, or at least the FTC articulates, is can you make a 5% price increase stick for a year? And antitrust is great for acronyms. There are all kinds of them, and this is one of my favorites. They use the phrase a small but significant and non-transitory price increase, which is abbreviated as the SSNP, which for some reason always makes me think of circumcision. And so, can you make a 5% price increase stick for a year? Now, this is a test that doesn't work perfectly in the healthcare context, because right now, as most physicians and hospitals are acutely aware, price increases aren't part of the norm. And it is possible that the government or an antitrust plaintiff could try to use a different test and argue that this 5% price increase test is inaccurate. But that's in the guidance right now, the sort of standard that's floated around. Can you make a 5% price increase stick? Or will output be diminished? Are there going to be fewer services available? Will there be less innovation in the marketplace? Or generally, is there harm to consumers? That's the sort of stuff that will tend to cause the government to say that this is monopolistic. But there are defenses you can make. And the defenses are, hey, no, we're going to increase efficiency. Or, and this is a huge one in the healthcare world, other people can enter the market. We don't know for sure why the Department of Justice ultimately gave up on the investigation on the merger I'm talking to. But I'll tell you the two arguments that I think were most persuasive. The first one was that the merger in question was about 60 miles away from a large academic medical center, which had a huge share of the market. And I think that when I say that 30 of 31 physicians in town were getting together, I think the market included the academic medical center and a few other medical centers which were within an hour's drive. And I believe that under the case law, that meant that the market share wasn't 30 of 31, but more like 30 of 120. So a big question is, what is your market and how far out can you draw those lines? But the second argument we made is that if we were to try to make a price increase stick, other competitors would enter the market. Other clinics would open up an office. Hospitals, who are regularly employing physicians, would acquire physicians and plunk them in town. And I think that's a very effective argument. And so if you're considering a merger and you're looking at your market share and saying the market share is 60% or 70%, you don't necessarily have to give up. You have to look at, A, is there a way to define the market more broadly than you have already? And I'll use an example from out west. An insurer said to a clinic, if you don't sign our contract, we're going to make our patients drive, we're going to send our patients to Salt Lake City, which was 120 miles away from the clinic in question. Well, I think that makes Salt Lake City part of the market of this location, because if you look at the test is where can people go? I think that payer, by threatening to send the patients there, was acknowledging patients might go that 120 miles for care. And in the Western United States, that's eminently believable. Poof, the market just got a heck of a lot bigger. Now, there's a very interesting story out there. I've been a big fan of divisional mergers for some time. There are some lawyers who fret about them. And those lawyers often point to Yakima, Washington, which had a merger that was challenged in the early 2000s because the FTC felt that the merger was a sham. And what the FTC looked at was what they perceived to be a total lack of integration. These were surgical clinics, and when they merged, nothing changed. They didn't combine anything. They each continued to operate as they were, and the only difference was they negotiated jointly. And so the settlement agreement said there were no efficiencies. And I wasn't involved in that case, so I don't know all of the details. But I would say that there are things that you should learn from that case. You know, if you're going to think about doing a divisional merger, consolidate some things. Heck, it pays. Consolidate your malpractice insurance. Consolidate your billing system. And try and do other forms of integration. If you have some integration, it's very difficult for the government to argue it's a sham. You don't want to do it offer ancillaries jointly. That sort of integration gets you out of what Yakima had. Yakima was about the worst facts you could imagine. And so I don't think that there are giant lessons there. Okay, last thing I want to cover are some other little hidden antitrust traps. This is one you may not think about, but peer review. Now, there are two kinds of peer review in the world. There's peer review within a clinic. That's not a problem from an antitrust standpoint. The kind of peer review I'm talking about is you are on, as a physician, a peer review committee at a hospital. And the hospital says, we've got concerns about a person in your specialty. Will you review that care? And the risk is that the physician subject to the review will say, the reason I'm being criticized has nothing to do with my actual quality of care. It's because competitors want to drive me out of town. Now, there's a law, the Federal Healthcare Quality Improvement Act, designed to address this. It's imperfect. And so it's just something to think about. It isn't a reason not to participate in peer review. It's just something to be aware of, and it's something to think about. So for example, if you're reviewing a competitor, the easiest thing to do, make sure you get a review, an outside review at some point done by someone who isn't a competitor of the practitioner in question. It just helps provide protection. Whenever you're doing a joint venture, if you're thinking about offering a joint MRI, you have to think about the risk that someone's going to argue that you are reducing the market share. So think about, why are you entering into the deal and how big your market share is. The closer you are to a monopoly, the higher the risk. If you don't have to share information about pricing with your joint venture participants, don't. Joint ventures can work. It's just something to keep in your mind. A couple of last quick points before we go to questions. Remember, you can ask questions in the bottom right corner. So, is it okay for you to call up a competitor and ask for their fee schedule? Can you ask, what do you charge for a 99213? What do you charge for a stent placement? What does a 3-day hospital stay cost? And the answer, most people think the answer to that is no, but the answer is yes, you can ask for that information. You remember the whole conscious parallelism discussion. Target knows what Kmart charges and vice versa. What you can't do is agree on price. And the reason when competitors are sharing price information, they often like to do it through an outside vendor, is to help reduce the risk someone characterizes their knowledge as an implicit agreement. But knowing someone else's price information, if there isn't agreement, is legal. You just want to take steps to try to make it clear that there's no agreement on price. Last two slides here. So this is a topic, I am not an expert on this, but it's something to keep in mind when to the extent you're selling goods and not services. People often think that discrimination is illegal. And they might even think you have to charge everyone the same price. Generally, you don't. You can have different prices for different patients. In the healthcare world, we almost routinely have different prices for different patients. Insured patient one, if a patient has insurance 1 versus insurance 2, they probably are paying different rates for the same encounter. That's okay. But when you start doing pricing for goods, it's different. And there's an act called the Robinson-Patman Act that gets triggered. Not my area of expertise, not Jim's. But when you are selling goods and not services, worry about it. When you're selling services, you can have different prices for different folks. There might be other rules that come into play. So, for example, Medicare would say you can't give a discount to more than half of your patients. You have to make sure that at least half of your patients are paying the Medicare rates or more. But antitrust laws don't come into play here. And I guess that's the last slide. Jim, I think we've got some questions. I'll let, you want to read through them?
Well, we've gotten just a couple questions. So we have some minutes left here. So if you have a question, feel free to send that to us. Question I have here is about in the future ACO models, will Medicare seniors still have annual open enrollment for benefits from Medicare Part D plans? Does the ACO risk model supplement or replace the existing fee-for-service payment model? The ACOs are to coordinate items and services under Medicare Part A and Part B. So it's not part of the Medicare prescription drug benefit program. I don't know if that Part D was referring to something differently, but ACOs are designed to coordinate items and services for inpatient and for hospital services, inpatient and outpatient, and physician services under Part A and Part B. And so that's how that would work. I haven't seen anything yet that really talks about how to integrate other parts of the Medicare cost program into this. Their focus with ACOs is primarily on these service elements as opposed to prescription drugs and other things.
All right, so I'll do this next one, which is, are you going to talk at all about leases of block time? I'm interested to know if leasing a time for imaging is an acceptable model. And that's a topic that covers about 15 different health law things, it feels like, but let's talk about the antitrust part of this. Generally speaking, it's perfectly okay for someone to use a supply that's leased from someone else. The antitrust laws aren't going to prohibit that in any meaningful way. Where the only thing that would become, I think, more challenging is if the two parties are agreeing that on what they're going to charge for those MRIs. But if Clinic A and Clinic B, or Hospital A and Hospital B, decide to share an ancillary, and they're going to use it, one will use it in the morning and the other in the afternoon, that's completely kosher and doesn't really raise any antitrust implications unless there's an agreement between them. Otherwise, they're just separate providers of a service, and whether you own or lease the equipment doesn't have any real antitrust implications.
This is an interesting and good question I got that states that I had mentioned that IT can or must be used to indicate integration. And how does the progress then of coordinating IT among healthcare providers under healthcare reform and high tech and so forth, how does that balance? If we're going to have abilities for our electronic medical records and information systems to coordinate across systems, then how does IT fit into this? And here's my take on that. Remember that I said that one of the factors that the government looks at with these networks and ACOs will be, was it necessary to contract with the ACO? Was it necessary to contract with the network in order to gain the efficiencies, or could you have done this anyway without contracting with the network? And if electronic health records, we have more interoperability, and we can coordinate care across providers anyway without necessarily joining a network, then that IT factor is something that's available anyway. So the IT that the network would have to provide is some kind of IT that now monitors cost of care, not just coordinating care, but cost of care, so that we're monitoring not only the care being provided, but its cost. And that's an element of IT that's only available in the network, not available outside of the network, and therefore participation in the network was necessary in order to gain the claimed efficiencies.
Okay, well, so next question, how do you determine the size of the market? And I'm realizing I probably didn't articulate that super well. So basically you have to figure out, so I guess we've got to, first you figure out the product market. So let's say it's hospital services. Next, you're looking where can people reasonably go for care, how many people are there and in that area, and you start drawing circles. And it's actually a fairly complicated process, but you're trying to figure out where people can turn, who are the possible providers, that tells you how, where they might go, and then you look at how many people go to each. Now, whether you look at dollars of services provided at the place or number of people who walk in, there's no obvious answer to that. And you have to choose that based on kind of logic of what's going on.
I'll do one more, and then maybe David, there's one more here, and then we'll wrap it up for the day. Question I have is when we're considering market share and we're looking at specialties and we're looking at multi-specialty groups merging, how does that work? And the way I've analyzed that before is that I look at each specialty within the multi-specialty group that's merging to see, so for example, if you've got a multi-specialty group that's got, let's say, urology and it's got orthopedics, just to be simple. So you've got a urology, orthopedics multi-specialty group merging with another one. I would look at what's going to be the market domination of that combined group in urology, and then what's the market power of that combined group in orthopedics, and testing whether the merger of those two groups would be lawful. My analogy to that is sometimes you'll hear about businesses who are merging that have to divest their units in order for the merger to go through. That's the same sort of thing. If the merger of two multi-specialty groups meant that the merged group would have 100% of the urologists in the market and only 30% of the orthopedic surgeons, I mean, theoretically you could say, well, they can merge the orthopedic parts of the group, but the urology parts need to be divested.
Okay, and there are two more questions I'll just do really fast because I think we can cover them both quickly. So first, can you clarify your last statement about different prices for the same service? So basically, you can have different prices for the same service. That is not improper. It's proper, as long as if we're talking services and not goods, you can have different prices for services. It might be unfair, it might irritate people, but it's legal. But for example, Medicare has a rule that says you can't charge Medicare more than your median price, which is the price where half the people are paying more. Medicaid in different states has different rules. In some states, it'll say you can't charge Medicaid more than you charge your biggest payer or your lowest price. You have to know what your own state law is. Last question here. What about negotiating jointly among healthcare providers for lower prices on medical equipment or services? And this is a great question, especially because it illustrates a point that I only alluded to briefly, which is the antitrust laws tend to favor buyers. And so generally speaking, collective purchasing is going to be far less risky than collective selling. There are situations where getting together on a buying cooperative can be problematic, but it's basically you need to have market power. And it is hard-pressed to think of a scenario where anyone who's on this webinar is going to have sufficient market power in the healthcare purchasing market for it to be a concern. So getting together to buy and get economies of scale is going to be kosher. So I guess this, I think, will wrap it up. Remember, first of all, that the next webinar, Steve Helland is going to talk about purchasing, what you need to know in computer contracts. So I think it'll be everything from electronic health records to other technical contracts, traps for the unwary. Please fill out your evaluations. If there are other topics you're hoping we'll cover, please let us know. And otherwise, Jim and I say thank you very much for attending. Have a great day.